Hello, welcome to Workplace Wake Up. I'm Jen Shaw. Every week, I spend about 15 minutes covering key legal developments, introducing you to interesting guests, and providing some entertainment to start your workday. I hope you enjoyed this week's episode. I feel like I need to take a really deep breath because there is so much going on out there in employment law. It is really hard to keep up with it. So, today, we are going to talk about DEI, diversity, equity, and inclusion. Some of us add B for belonging. There are all sorts of other terms we could add, but DEI generally, right? Diversity, equity, and inclusion. Now, over the past several weeks, the president has issued several executive orders. Last week, I talked about the Equal Employment Opportunity and the gender-related executive order. Today, we're going to talk about DEI. Okay, first of all, let's set the stage. As you know, on January 21st, the president issued an executive order targeting diversity, equity, and inclusion initiatives. And that order applies not only to the federal government, but also in the private sector, which is unusual, and we're not even clear if he can do it, okay? So as I mentioned last week, when an executive order is challenged, it's challenged on constitutional basis. So we're probably going to end up before the U.S. Supreme Court on where are these guardrails? Where's the bumper on how far a president can go with executive order? In the meantime, as human resources professionals, we have to figure out what the heck we're supposed to be doing. So this executive order on DEI directs federal agencies to combat what they call private sector DEI preferences, mandates, policies, programs, and activities, and to, quote, encourage them to implement a policy of individual initiative, excellence, and hard work. Okay, this executive order creates way more questions than it answers, but I want to give you some things to think about that I think will help. Okay, first of all, no doubt about it that if you're a federal contractor or a subcontractor, you're going to have to deal with this issue pretty square on, okay? So you're going to need to look at your DEI programs and even things that you don't call DEI, but that may have the same impact or the same intent. You're going to have a look at those and figure out what you're going to do. We don't know what the federal agencies are going to do to carry out the executive order or the initiatives that are listed in the order. And in terms of federal agencies, we're talking about the Equal Employment Opportunity Commission, the National Labor Relations Board, OSHA, Department of Labor. There are a number of different agencies here that we need to deal with. We don't know how that's going to come about. But what we do know is that there is a lot of talk and a lot of movement on the DEI front. Now, again, this podcast is not political, so I'm not taking a position on the president or the executive order. I just want you to know what you need to do here. The first problem with the order, though, is it doesn't define what they call illegal DEI, okay? That term, that phrase, is used throughout the executive order. We think it defines prohibited conduct as illegal discrimination and preferences and any sort of informal or formal workplace balancing based on a protected category like race, color, sex, religion, or national origin. However, Title VII already has those protections. So it's not clear what is new here because Title VII has always prohibited quotas unless the court has ordered an employer with a historic record of discrimination to use quotas as a way to get them where they need to be. But that is a rare occurrence, particularly these days. So the idea, we think, of the executive order is to really look at making merit-based decisions, which of course is what DEI is all about in the first place if you look at it from an HR perspective. We were never trying to give preference with the DEI program. We were trying to make sure people had equal access, equal opportunity. That was the point of DEI. Now, was it misused? Of course. Some folks, some organizations went too far. But that's the idea of DEI. Now, the order actually wants to eliminate the Office of Federal Contractor Compliance Programs, the OFCCP. So again, if you're a contractor or a subcontractor, you got to figure out what's going on here, particularly because the new chair of the EEOC, the interim chair, Andrea Lucas, she spoke specifically in her press release when she was elevated to this role about rooting out unlawful DEI motivated race and sex discrimination. Okay. But there's no question that even under the order, it is lawful for employers to implement DEI and accessibility programs that have the purpose or the intent of ensuring that workers of all backgrounds are afforded equal employment opportunity. That's what Ms. Lucas said, and that's obviously what the law is at this point. Federal officials are going to have to submit recommendations for ending these, quote, illegal DEI practices. They have to do that within 120 days of January 21st. They have to prepare a report, and they have to include in that report recommended measures to encourage the private sector to end illegal discrimination and preferences, as well as include a proposed strategic enforcement plan. So if you're in the public sector, okay, and you are a federal contractor, you've got to act quickly. If you're in the private sector, oh my gosh, they're encouraging you through the executive order to eliminate DEI, okay? It's just not clear what that means. So what we're looking at is, even if something doesn't have a DEI label, are we in our organizations behaving fairly and consistently? So DEI is not supposed to be a preference program. It is supposed to be a way to ensure equality, fairness, to promote equity. Okay, that's what's supposed to be happening with DEI. Okay, so what they're looking at in the private sector, according to the executive order, is that some private businesses are going to be targeted for what they call civil compliance investigations. So the idea is publicly traded companies, large nonprofit corporations or associations, we don't know what they mean by large, and foundations with assets of $500 million or more, state and local bar and medical associations, and institutions of higher learning with endowments of over $1 billion can be targeted for these investigations. Okay. And what the order asks the federal agency to do, each federal agency is supposed to identify up to 9 potential investigations. So they're supposed to go out and look for employers and organizations that they feel have gone wrong when it comes to DEI. Now, interestingly, the executive order does not apply to private sector employment that falls out of those definitions, and any current contracting preferences for military veterans and individuals with disabilities. Okay, so those are protected. Okay, what do you need to do right now? What do we need to focus on? Okay, the first thing to remember here is that a well-designed and appropriate DEI program is not unlawful. It's not illegal, okay? You need to look at your hiring, your training, your promotion, and your termination practices in light of the order. You need to make sure that there are no preferences, there are no quotas, nothing of the sort, okay? So what you want to look at is, what is your DEI program and how do you measure its effectiveness? There's no question that studies have shown the value of DEI programs in the workplace. They increase collaboration, they increase productivity, they give you a better bottom line, they encourage stronger leadership. There are a lot of different benefits we get out of DEI type programs. But certainly if your business falls under one of those categories I just mentioned that could be targeted by a federal agency, you're going to want to go through all of your programs with a fine-tooth comb. If you are not covered by those descriptions, the publicly traded company, large nonprofit, a foundation with, $500 million in assets, et cetera. If you don't fit in those categories, you should still look at your programs and make sure that, number one, on their face, they're not doing anything that looks discriminatory or in any way encourages a quota or any sort of a system. You want to be very careful about that. That doesn't mean you throw out the baby with the bathwater. We still want to do what's right. We still want to make sure that we are encouraging equality and equity, that we're giving everyone an opportunity and a chance to succeed and to do what they want to do. So I really want to encourage you not to just throw out the program. You just have to look at it and make sure that the way it's being written and the way it's enforced are both consistent with the principles of equality, not favoritism, not what we sometimes hear referred to as reverse discrimination. Okay, that's not where you want to be going with these. Now, we're expecting in the next couple of months that we're going to get more information about this whole DEI movement from the new administration and what it means and what their goals actually are. As we talked about last week with respect to the gender executive order, it's pretty clear to me that the point of that order is they want to get up to the U.S. Supreme Court to reverse the Bostock decision, because the Bostock decision is where the Title VII was interpreted by the court on a 6-3 majority as including LGBTQ plus protections. Okay. And that was the first time the U.S. Supreme Court made that clear. It seems apparent that one of the goals is to try to get that case overturned. And I have no idea. Your guess is as good as mine about what the U.S. Supreme Court might do. But with respect to DEI, we've already got those decisions that came down a bit ago involving admissions at colleges and universities, right? So we already got some clarification on that front. I am hearing from colleagues that the California legislature is looking at what it wants to do in terms of shoring up the protections we have in our state and making sure that we can do what is possible to avoid the implications of whatever federal changes are coming in these critical areas. But I don't know how that's going to shake out. For now, you need to pay attention. You need to look at your DEI programs and really look at them from a fair perspective. Put your lens on of how does everybody think about this program? How could it be interpreted? And can you do something to fix that? Can you do something to remedy that issue? If you take the time to do that, and rather than focusing on DEI as a thing, but focusing on it instead as kind of a movement, a culture, right? That we're just trying to do what is right. We are trying to make decisions for legitimate business reasons. Just as the executive order says, to reward individual initiative, excellence, and hard work. That's the point. That's what we should all be aiming for, no matter what we're calling it. So it's going to be interesting to see where this goes and how the courts look at this particular executive order. Like I said, the basic foundational problem here is they don't even define what an illegal DEI program is. So we're going to need some help on that front. But in the meantime, take a look at your programs, take a look at your equal employment opportunity policies, your discrimination, harassment, and retaliation prevention policies. Make sure they are in order. Make sure that they are written in a way that is fair and equitable and that communicates your desire as an organization to be fair and to make decisions that are legitimately based on somebody's ability to do the job. Okay? If you do that, you're going to go a long way toward avoiding liability in this area. I know there's a lot going on. Go outside, take a bike ride, take a long run, eat some chocolate, do whatever makes you feel better. And I will see you here next week. Thanks, everybody. Workplace Wake Up, including our guests and hosts, do not provide legal advice in this podcast. Do not act upon any of the information discussed in this podcast without first consulting a licensed attorney in your jurisdiction. If you enjoyed this episode and would like to spread the word, please share it with others. Post about it on social media and/or rate and review it. You can also follow us on LinkedIn, Twitter, and Facebook, and email us at info@shawlawgroup.com.